Hello, my name is Alice White. I'm the Registrar of Wards of Court, and I would like to explain some changes that we have introduced in the office in relation to discharge applications for wardship. As you're all aware, the Assisted Decision Making Capacity Act commenced on the 26th of April 2023. The Wards of Court Office have a 3-year time period under the Act under which every ward of court is to be reviewed, is to have their capacity assessed and subsequently discharged from wardship with one of the 3 tiers of support available under the Act. So we had approximately 2,300 wards of court on the 26th of April 2023. We declared a further 211 wards of court in 2023 and a further 21 in 2024. We have discharged 152 people from wardship, and we have approximately 1,700 relevant people or wards of court awaiting discharge, but we also have received 800 applications for discharge, and those applications are currently being worked on and are at various stages in the office. So the decision supports. The decision support service and it's at the commencement of the Act. So substituted decision making being replaced in Ireland. As mentioned, every adult ward of court will be discharged from wardship. The relevant person will be assessed and will align with one of 3 tiers of support or may require no decision support upon review. So a person may be discharged from wardship with no support, as mentioned, with the support of a decision-making assistant, which is the lowest tier of support, the support of a co-decision maker, which is a middle tier of support and sees decisions made jointly with the relevant person, or discharged with a co-decision-making with a decision-making representative, a DMR, which is the highest tier of support and is the one that's most closely aligned with the current role of a committee. At all times throughout the application, consideration must be given to the guiding principles of the Act, which are outlined in Section 8 of the Act. So, High Court Practice Direction 133. This is a new practice direction that was brought in to replace High Court Practice Direction 120. So the main changes in the practice direction, it was to simplify the discharge procedure for practitioners. And this was done in a few different ways. One, it specifies that service on the relevant person is to be carried out by a solicitor and in accordance with Order 67, Rules 94 and 95 of the Rules of the Superior Courts. It provides that documents will be served on the relevant person once, and service on the relevant person is personal service. So this was a change. Under the provisions of High Court Practice Direction 120, there were 2 separate sets of documents to be served on the relevant person, and now that has been reduced to 1 set of service. It also provides that the functional capacity assessment report can be conducted by a registered medical practitioner in addition to the court's medical visitor. So again, we've widened that definition of, or widened that criteria of who will carry out the assessment. So again, looking at High Court Practice Direction 133, what it doesn't change is who can bring the application. So as previously, this is set out. Who brings the application is provided for in the ADMCA Act. And the committee can bring the application. The ward of court can bring the application. Or on consent of the court, a relative or a friend, a person who's in a position of trust with the relevant person. But also it can be a person who has a professional interest and expertise. So somebody maybe who is working with the ward of court or the relevant person can bring the application. Now, those consent applications are done ex parte. They should be grounded on an affidavit setting out the reasons why this person is bringing the wardship application. An example of where you might see this being used is that somebody from a service provider might decide to initiate the application. So the discharge application itself is commenced by way of a notice of motion which must be filed in the wards of court office. And can I just set out that there is a deadline running now, and it's not just the 3-year review. Anybody who does not have a discharge application lodged 6 months ahead of the 3-year review period, which is the 26th of October 2025. That is your deadline to get motions in. If your motion isn't in by that date, the matter will be listed before the court for directions. So no posting your motion on the 25th to get it in here. The latest you should be leaving to post your notice of motion is the 22nd or the 23rd of October. So the wards of court office will request and arrange for the functional capacity assessment to be completed by the court's medical visitor or by a registered medical practitioner. We will provide the assessment report to the solicitor, to the ward of court, to the committee. If the notice party is, if there's a notice party to the application, they would also be provided with a copy of the report. If at any point the relevant person, the ward of court or their committee decide that they're not happy with the assessment recommendation, or if they want to obtain their own independent report, they are free to do so, and this can be submitted for consideration by the court. So it is open to the relevant person or the committee to obtain their own functional capacity assessment. The grounding affidavit must set out the will and preference of the relevant person. So when you meet with your client, with the relevant person, you should attempt to gather what their will and preference is. And this could be in relation to possibly where they want to live, who they may want to help them with different types of decisions. Maybe they want more than one decision support person. Maybe they would like to go with somebody completely new. They don't want a family member anymore. Maybe there's a difficulty in relationships. So this is all areas that can be explored and recorded as in the words or the relevant person's will and preference. And as I've already mentioned, service is personal by a solicitor on the relevant person, but service on the committee or any other notice party can be by registered post. So the capacity assessment itself, the court's medical visitor or the registered medical practitioner will carry out the assessment. And the committee, the relevant person, can obtain their own. The assessment will look at the relevant person's capacity in the areas of welfare, to include healthcare and property and finance. And it will look at the person's ability to understand the information relevant to making that decision. Their ability to retain the information long enough in order for them to make a decision. And also their ability to weigh up and use the information they've been given as part of the decision-making process. Like, are they able to identify what the pros and cons are, what the benefits are, or the possibly the negatives of a decision? So they also need to be able to communicate their decision. And communication, it can be in a number of different forms. It can be spoken, it can be written, it can be using sign language, or assistive technology, or even communication through the means of a third party. When the report will make a recommendation to the court, but ultimately it is the court that makes the decision in relation to the tier of support. So the discharge application in relation to the other documents, the wards of court office, as I've mentioned, will arrange and circulate the functional capacity assessment report. The wards of court office will also prepare a document setting out all the assets of the relevant person or the ward of court. This will be provided to the solicitor as part of the application. We will also provide you with copies of any relevant orders or reports from the file, and this could be medical treatment or a detention order. It might be an order setting out that there's restrictions in relation to certain family members. Any of those orders that are relevant to the discharge application will be provided to the solicitor by this office. The office may require some information on how the funds, or a proposal on how the funds are to be managed post-discharge. So this would be where there's an excess of 250 to 300,000 lodged in court. We are not looking for a detailed investment prospectus. What we would like to see is an outline of how the funds will be managed, or an outline of where they are going to be invested. If the decision-making representative, the DMR, has been recommended as the tier of support, there is a statement that the decision-making representative must sign and have returned to the office. That's a statement confirming that they are eligible, or that they're not ineligible from acting as a DMR, or that they aren't disqualified under any of the criteria. And those criteria are set out in sections 38 and 39 of the ADMCA. We have a sample of this form. If a decision-making representative is the recommended tier of support for the relevant person that you're representing in the application, we can provide this form to you for completion. So in relation to service of the documents and the affidavit, in relation under section 54(1), which is the application for discharge from wardship, the solicitor will serve the functional capacity assessment report, the scheduler statement of assets, any other reports that are relevant to the application. The solicitor is also responsible for ensuring and encouraging participation and attendance in the hearing, and section 139 sets this out in the ADMCA. So this must be referred to in any affidavit that is filed. So, and as I've set out, reg post service on the committee or any notice parties, personal service by a solicitor in accordance with Order 67, Rules 94 and 95 on the relevant person or the ward of court. As part of the service of these documents, the solicitor will explain what the application is, what the implications are of the application, and record any response, views, or opinion that the relevant person has. We've covered that the will and preference of the relevant person would be gathered at this stage and recorded also. So in relation to, we have the discharge hearing. The notice of motion will issue for service with all of the other documents that I have already mentioned. The hearing date will be on the return date on the notice of motion will be the discharge hearing date. This can be attended remotely or in person. If you are attending remotely, and a lot of relevant people and wards of court prefer to attend remotely with assistance being given to them to attend, they all do have the option of attending in person as well. Links will be provided ahead of the hearing date to attend remotely if that's the option. When the relevant person is discharged from wardship, if they're discharged with requiring no level of support or a decision-making assistant, their assets will be returned to them as soon as possible. But please note, it takes about 3 to 4 weeks for the accountant's office to close off an account held there. So there is that minimum time period. Now, if a person is going to be discharged with a co-decision maker, the co-decision making agreement must be registered before the funds are returned to the relevant person. The co-decision making agreement is an agreement that the relevant person and their proposed co-decision maker, with the assistance of their solicitor, will draft to register with the Decision Support Service. Now, I have been informed by the Legal Aid Board that the legal aid certificate that issues under the Part 5, under Part 6 for the discharge process, can be amended to a legal aid certificate under Part 5 to allow for the application to register the co-decision making agreement with the Decision Support Service. Now, if the person has been discharged with a decision-making representative, the order discharging the person acts as the decision-making agreement. So the decision-making representative order will act as the agreement. The wards of court office will send an unofficial copy to the Decision Support Service, but ultimately it is the responsibility of the solicitor moving the application to file the decision-making representative order or to register it with the Decision Support Service. And as with registration of a co-decision making agreement, once this office is in receipt of notification that the order is registered, we will arrange for payment out of the funds that are held in court. Now, to facilitate the payment out of funds, the relevant person will require a bank account, and that is something that the client, if they do not have a bank account for the relevant person, if the committee doesn't have one, or if the committee is going to be a decision-making representative, they may have a committee account which can be altered, have the title altered. All of that would be subject to approval by the individual banks, and it is always recommended that inquiries be made of the bank's requirements early on in the discharge process. Thank you.